It happened at 2:47 a.m. Eastern Time. While you were sleeping, the Supreme Court issued an emergency order that fundamentally alters how federal power works in America. No press conference, no advance warning, just 6 justices deciding in the middle of the night to rewrite the rules. And here's what almost nobody is reporting yet. This isn't about one law. This isn't about one policy. This is about who gets to decide what the Constitution actually means when the government comes for your rights. The case is Miller versus Department of Homeland Security. The issue on paper? A challenge to new deportation procedures. But what the court actually did, they just changed the entire framework for how Americans can challenge federal actions in court. I'm going to break this down in plain English because the legal community is in absolute chaos right now, and you need to understand what just shifted beneath your feet. Here's what happened. At 2:47 this morning, the Supreme Court ruled 6-3 that federal courts can no longer issue what's called universal preliminary relief. That's the legal term. Here's what it actually means. For the last 30 years, if you believed the government was violating your constitutional rights, you could go to federal court. And if a judge agreed with you, that judge could issue an order stopping the government from doing that thing to anyone anywhere in the country while your case moved forward. One person, one lawsuit, protection for everyone. That's over. As of this morning, a federal judge can only protect the specific people who actually filed the lawsuit. Everyone else? You're on your own. You have to file your own case, hire your own lawyer, wait your own turn. The majority opinion was written by Justice Alito, joined by Roberts, Thomas, Gorsuch, Kavanaugh, and Barrett. Their reasoning is straightforward and, honestly, brutal in its simplicity. They say the Constitution gives courts the power to resolve disputes, not to act as a national veto over executive action. If you're not a party to the case, you don't get relief. Period. Justice Thomas went further. He wrote separately to say that nationwide injunctions have been weaponized. That activist group's forum shop for friendly judges to shut down policies they don't like. He called it judicial overreach masquerading as constitutional protection. But here's where it gets real. Justice Sotomayor wrote a blistering dissent, joined by Kagan and Jackson. And she didn't mince words. She said this ruling creates a 2-tiered system of justice. If you have money for lawyers, you get constitutional protection. If you don't, the government can violate your rights with impunity as long as you personally haven't sued yet. She called it a return to pre-civil rights era jurisprudence, where your rights depended on your zip code and your bank account. Now, before you think this is just legal theory, let me tell you what's already happening. Because the aftermath started before sunrise. At 6:15 a.m., the Department of Homeland Security sent an internal memo to field offices. I've seen it. The guidance is clear. Enforcement actions that were paused by court orders can now resume immediately in districts where there's no active plaintiff. By 7:30 a.m., the Texas Attorney General filed emergency motions in 4 separate cases. They're asking judges to narrow existing injunctions down to only the named plaintiffs. If they succeed, immigration enforcement policies blocked for years could restart within days. By 8:00 a.m., California and New York filed counter motions. But here's their problem. Under the new framework, they can't protect their residents unless their residents are the actual plaintiffs, and most aren't. At 9:15 a.m., the ACLU held an emergency internal call with over 200 staff attorneys. I'm told the message was stark. Every major case they're litigating just became exponentially more expensive and less effective. The American Bar Association issued a statement at 10 a.m. calling this the most significant shift in civil procedure in modern history. Think about what this means in practice. Let's say the government issues a policy that you believe violates the First Amendment. Maybe it restricts speech. Maybe it targets religious practice. Under the old system, one lawsuit could protect everyone while the courts decided if the policy was constitutional. Now, the government can enforce that policy everywhere except against the handful of people who sued, and even if those people win, the victory only applies to them. Everyone else has to file their own case. And wait, and hope they have the resources to fight. We're talking about a system where your constitutional rights are protected only if you personally can afford to enforce them. Immigration law is the immediate flashpoint. There are currently 23 active nationwide injunctions limiting various immigration enforcement practices, everything from detention procedures to deportation priorities to asylum processing. Under this new ruling, those injunctions may now only protect the specific immigrants who filed the cases. The Department of Homeland Security could theoretically enforce the blocked policies against everyone else starting as early as next week, but it doesn't stop there. Voting rights. There are injunctions protecting voters in multiple states from what courts have found to be discriminatory practices. Those protections may now only apply to the named plaintiffs. Gun rights. Several states have firearm regulations blocked by federal injunctions. Those blocks may now be limited to the specific people who sued. Healthcare access, environmental protections, workplace safety, education. Every single area of federal law where someone challenged government action is now in flux. We're potentially looking at a country where federal law exists on paper, but enforcement looks completely different depending on where you live and whether you personally filed a lawsuit. Constitutional scholars are calling this the most significant federalism shift since the New Deal. Some are going further. They're saying this fundamentally changes what it means to have constitutional rights in America. Because here's the philosophical question at the heart of this. Are your rights something you possess inherently, or are they something you have to affirmatively claim in court with your own resources? The majority says rights are individual. If the government violates your rights, you sue. You get relief. But the remedy is personal to you. The dissent says that's a fiction. That constitutional violations are structural. When the government acts unconstitutionally, it harms everyone, and courts should have the power to stop that harm for everyone, not just people with lawyers. Now, I want to be clear about something. This ruling has support from serious legal minds across the political spectrum. There are legitimate concerns about judicial overreach, about one judge in one district overriding the elected branches of government for the entire country. Justice Gorsuch made this point in his concurrence. He said nationwide injunctions encourage forum shopping, that advocacy groups deliberately file in districts where they know they'll find sympathetic judges, and that this undermines democratic accountability. There's truth to that. We've seen it happen. Conservative groups filing in Texas, liberal groups filing in California, both sides hunting for favorable venues. But the counter-argument is equally powerful. If the government is acting unconstitutionally, should it matter what your address is? Should protection from unlawful government action really depend on whether you personally had the money to file a lawsuit? The economic impact is already being calculated. Major law firms are sending memos to corporate clients. The guidance is blunt. Constitutional litigation just became 5 to 10 times more expensive. Instead of one lawsuit providing nationwide clarity, companies may need to defend or challenge policies in dozens of jurisdictions simultaneously. The compliance costs are going to be staggering. We're talking billions of dollars in legal fees, billions more in regulatory uncertainty, and that's before we even get to the cost of fragmented enforcement. Imagine you're a healthcare company operating in all 50 states. Under the old system, if a federal health regulation was blocked by a court, you had clarity. The regulation didn't apply anywhere while the case proceeded. Now, the regulation might be blocked in the Ninth Circuit but enforced in the Fifth. You have to comply with one standard in California and a completely different standard in Texas. Multiply that across every regulated industry. The business community is not happy about this, and neither are the states. Within hours of the ruling, attorneys general from both red and blue states issued statements. And here's what's remarkable. The criticism is bipartisan. Republican AGs are worried about their ability to challenge federal overreach. Democratic AGs are worried about their ability to protect their residents from what they see as unconstitutional federal action. Everyone just lost their most powerful tool. Now, there's a deeper constitutional question here that the court didn't fully address, and it's going to be the battleground for the next decade. What is the role of federal courts in a system where the executive branch has vast discretionary power? The framers designed 3 co-equal branches. But if courts can only protect people who sue, and if most people can't afford to sue, does that make the executive branch effectively supreme in practice? Justice Jackson raised this in her dissent. She said the majority is creating zones of constitutional immunity, places and people where the government can act unlawfully simply because no one has the resources to challenge it in court. She called it the aristocracy of litigation. Rights for those who can afford them. The majority's response? That's a policy argument, not a legal one. Congress can fund legal aid. Congress can create statutory rights with their own enforcement mechanisms. But courts can't expand their own power beyond what Article 3 of the Constitution allows. And according to the majority, Article 3 doesn't give courts the power to protect people who aren't parties to the case. Here's what happens next. Lower courts are going to be flooded with motions. The government will move to narrow every existing nationwide injunction. Plaintiffs will fight to preserve them. Judges will have to apply this new framework to hundreds of pending cases. We're looking at months, possibly years, of legal chaos as the system adjusts. And then there are the strategic implications. Advocacy groups are already adapting. They're talking about filing coordinated lawsuits in multiple jurisdictions simultaneously, trying to recreate nationwide protection through sheer volume of litigation. But that's expensive, prohibitively expensive for most organizations, which means the groups with the most resources will have a massive advantage. This is what Justice Sotomayor meant when she said this creates a two-tiered system. The wealthy can afford to protect their rights. Everyone else? You're at the mercy of whether someone with money happens to be challenging the same thing you are. There's also a timing issue that's being overlooked. This ruling drops right as we're entering a presidential election year. Every major policy fight, immigration, healthcare, voting rights, environmental regulation, is about to get exponentially more complicated. Because now, even if a federal judge says a policy is likely unconstitutional, that policy can still be enforced against most people while appeals drag on for years. That shifts enormous power to whoever controls the executive branch. They can implement policies, enforce them broadly, and even if courts eventually strike them down, the damage is already done to everyone except the specific plaintiffs who sued. Corporate lawyers are calling this the litigation lottery. If you happen to be a named plaintiff in a successful case, you're protected. If you're not, you're exposed. Your rights depend on luck and geography. The international implications are also significant. The United States has long positioned itself as a champion of rule of law. We've criticized other countries for having legal systems where rights aren't uniformly protected. This ruling makes that argument harder to make. How do you tell another country to ensure equal protection under law when your own system now explicitly allows for fragmented constitutional protection? Legal scholars in Europe and Asia are already writing about this. They're questioning whether the American model of judicial review still serves as a template worth following. Now, I want to address something important. There are people celebrating this ruling, and there are people who are devastated by it. Both reactions are based on how you think this affects your side politically. But here's what you need to understand. This ruling doesn't favor conservatives or liberals. It favors power. Whoever controls the executive branch now has much more freedom to act without immediate judicial restraint. If you like this ruling because you think it helps your side right now, remember, power changes hands. What you're celebrating today could be used against you tomorrow. That's the thing about constitutional structure. It's not supposed to be about whose team wins. It's supposed to be about limiting government power, regardless of who's in charge. Whether this ruling does that or undermines it depends entirely on whether you believe concentrated judicial power or fragmented judicial protection is the bigger threat to liberty. The Supreme Court just made its choice. 6 justices believe nationwide injunctions gave too much power to individual judges. 3 justices believe this new framework gives too much power to the executive branch and too little protection to ordinary people. We're about to find out who's right. Because starting now, the legal landscape looks completely different. If you want to track how this develops, you need to subscribe. This story is going to unfold over months and years, affecting everything from immigration to healthcare to voting rights. And here's my question for you. Does this ruling restore proper judicial restraint, or does it create a system where your rights depend on your zip code and your bank account? Drop your answer in the comments, because this debate is just beginning, and your voice matters.